Order with quorum at 10:05. Clerk, can I get a roll call, please? Anybody? No clerk? Oh, Cam. Okay. No roll call. We weren't prepared for that, but we see that everybody's here. Can I get a motion to adopt the agenda, please?
So move. Second.
All those in favor say aye.
Aye.
All opposed? Motion carries. Next item on the agenda is public comments. I do notice that we see some representatives and attorneys from the court. Can you please introduce yourself and make it known to this body what you will be commenting on? And we can start from the beautiful lady on my left.
Good morning. Whoa. Good morning. Is this working? Good morning, Chairwoman and Vice Chairman. My name is Hyun Jae Lee. I serve as the General Counsel for the NMI Judiciary. We are here to address any questions regarding the guardianship rules. To my left is Acting Director of Courts Matthew Brown. Sonia Camacho is off island, but he's here to field any questions. If you do need to get in hold of Sonia, she says she's available to speak on the phone, so please let me know. And to the far left is Law Clerk Keith. He's the law clerk to the Justice John Manglonia. He was a leading law clerk for the guardianship rules. Thank you.
Good morning, committee members. My name is Robbie Glass. I'm the chief solicitor of the CNMI. I'm actually here to comment on the criminal bills that are here. So House Bill 2313, 2314, 2315, and 2317.
Thank you for that introduction. And just following the agenda, we will go ahead and address item 3, new business. Letter A, Judicial Branch Communication 231. Geez, everyone, I'm new to this. So can we get the representatives from the Supreme Court to go ahead and comment on the Judicial Branch Communication 231, Supreme Court proposed NMI rules of guardianship procedure? Thank you.
Oh, is that okay? That's working. Once again, I'm Matt Brown. I'm on here on behalf of the Director of Court, Sonia Camacho. We're here to comment. I believe she was here 2 weeks ago for initial public comment to, stress the importance of these rules and protecting some of the most vulnerable members of our community, that being minors, insanity, and incapacitated persons. Just to give a little bit of a background on these rules, they were sent to the bar on December 12th and given 30 days for comments. These rules were formally contained in the NMI rules of probate procedure. And then in late 2022, the Supreme Court Rules Committee decided that to promote clarity, it would be to extract some of these provisions on guardianship from the probate rules and place them in their own standalone set of rules. It makes it easier for attorneys and pro se litigants to locate, identify, and work with the guardianship rules. If passed, these rules will be accessed on the LRC website, so people from the general public will be able to easily access these rules and utilize them. This kind of goes hand in hand also with a current forms project the Judiciary is working on and making forms easily available to pro se litigants and more easily readable in plain English. They heavily rely on previous provisions and on 1 CMC section 1421, which is the NMI's guardianship statute. Kind of for the rules, I have Keith Catola here, who was the lead law clerk who worked more substantively on these rules. So if you have any questions kind of more painted toward the substance of these rules, he's here to answer those questions. But as for now, I'll rest. But that's basically just the background of these important rules.
Would you like to continue on?
Sure. Good morning, everyone. Again, so my name is Keith Catola, and I'm a law clerk for Justice Manglonia at the Supreme Court. I can just say a few words about some of the new provisions in these rules. So again, the rules really don't even though they're a new set of rules, technically speaking, they don't really represent a major change in the law. These rules were already in the rules of probate procedure, and we've really just extracted them and made some slight changes to modernize them. So some of those changes include Rule 2. A party can now move for the appointment of a guardian within an existing civil case. We think that this will promote expediency in our court system. Cases will not need to be put on hold for a separate action to determine guardianship. Rule 5, a guardian for an insane or incompetent person can now just be for the estate or just for the person or for both. And we believe this will simplify situations where an elderly person needs assistance only with finances or with day-to-day living, but not necessarily both. Rule 7, we have now an emergency summary proceeding for a guardian. And this allows expedited proceedings where there's a time-pressing need to appoint a guardian to protect the safety or affairs of a minor or an incompetent person. And this provision was based primarily on Hawaii law and Florida law. And finally, now, Rule 5, a guardian for an incompetent person can't be appointed without an affidavit or testimony from a licensed medical professional that the person is incapable of managing his or her own affairs. And we believe that this will serve to protect these individuals in cases where their status of incompetency is debated. So those really are some of the major changes. And again, they're not really major changes. The bulk of these rules already exist in CNMI law. Really, it's just a change from being within the rules of probate to being a standalone set of rules. So thank you.
The floor is still open for any other comments.
Thank you, committee members. As I said, my name is Robbie Glass. I'm the chief solicitor for the CNMI. I'm here on behalf of the Attorney General's office. So first I want to talk about House Bill 2313, which is the Dangerous Weapons and Serious Bodily Injury Bill. The AG's office strongly supports this bill. This is a much needed change for these definitions. It clarifies the term of what a dangerous weapon is. It also clarifies the term of serious bodily injury and allows prosecutors to more strongly prosecute these kinds of cases. We recently had a case within the last couple of years where a prison inmate took a toothbrush and sharpened it up and attacked the barber who was cutting his hair that day and left the barber with some serious injuries. And when we took that case into court to prosecute it, the judge found that that sharpened toothbrush didn't meet the definition of a dangerous weapon. And so that case ended up not being prosecuted to the full extent that it really probably should have been under justice. And so that's why we came in seeking to make this definition stronger so that these kinds of victims get the justice that they actually deserve. The 2314, which is the vandalism bill, the AG also supports this bill. When the vandalism bill first became law, I think it was back in 2020, I think it was 2020, I believe, maybe 2021, it didn't leave any jail provision within there. And without a jail provision, it's been very difficult to get any kind of probation on those cases. And probation on those types of cases allows the court to monitor that people are actually doing the community work service, that they're actually going out and doing the things that they're supposed to do under the law for it. While the bill did provide for a fine and community work service, there was nothing to really trigger any kind of supervision of that community work service. So our judges have been very reluctant on how they can go about doing that kind of a sentence. The jail term also gives wider discretion to the prosecutors and judges when it gets to sentencing, right? There are some vandalism crimes that probably deserve jail. That does not mean all of them do, but the ones that do, they don't even have that option. And so if somebody went out and vandalized something that was worth $150,000, the most that they could get punished with is a fine and some community work service. So that makes it very difficult on the prosecutors to do their job properly and ensure justice for these individuals whose property was damaged. And so we need that jail term in there. And so we strongly support that being placed in there under this bill. 2315 is a public corruption bill. I don't think our office has actually provided formal comments on this yet. So we'd welcome working with this committee on drafting a new public corruption bill. There's obviously some things that we would like to see in there, see some different levels of misdemeanor and felony levels of public corruption. see maybe some broader ranges of punishment and things. So we'd like to work with the committee on that. 2317 is the prison contraband bill. Again, this is another bill that the AG supports. Currently, we don't really have much of a contraband bill for prison contraband. And so when an inmate is placed into the Department of Corrections, there are a number of items that you might be able to have on the outside that you can't have within a prison. And cell phones being one of probably the easiest, most thought out ones. Cell phones often can be used to plan things on the outside. They might be used to plan escapes. It might be used to plan to commit other crimes against people in retaliation. And these are actually very dangerous things within a prison community. And so this bill would actually prohibit those kinds of items from being brought in. It would also provide more local ability to prosecute those kinds of crimes. Recently, I believe there was a prison official that was charged with bribery under the federal crimes. We didn't have anything locally that we could have really worked with and done to prosecute that individual on the local side. And so this is a bill that would give us some ability to do that. And so we support it for those reasons. Thank you.
Are there any more public comments? I see that there's none. We'll move on to item number 3, new business, subsection A, which reads Judicial Branch Communication 23-1, Supreme Court proposed NMI rules of guardianship procedures. And the floor is open. Yes, Vice Chair.
Thank you, Madam Chair. And being that the representatives from the judicial branch have made the necessary comments regarding judicial branch communication 23-1 from our previous discussion, maybe I'd like to propose that we adopt judicial branch communication 23-1 if there's no objection.
So there's a motion to adopt Judicial Branch Communications 23-1, Supreme Court proposed NMI rules of guardianship procedure. There's been a second. All those in favor say aye. Aye. All opposed? None. Motion carries. Supreme Court proposed NMI rules of guardianship procedures has now been adopted. Thank you, members.
Thank you, Madam Chair.
And we move on to our next order of business, subsection B, House Resolution 23-3 to encourage the Honorable Governor Arnold I. Palacios and the Honorable Lieutenant Governor David M. Apatang to officially adopt a general policy to prevent the employment of people from being used as a personal political tool by freezing the hiring of non-essential employees with or without number of positions, NOPs, provided in a budget enacted by the CNMI legislature 180 days leading up to an election. Floor is open. Vice Chair.
Thank you, Madam Chair. And also, as previously discussed, I'd like to move that we table House Resolution 23-3 for further discussion in the committee. There's no objection. I'd like to move that we table House Resolution 23-3.
And any objections? No objections to placing? I'm sorry. All those in favor to table House Resolution 23-3, say aye. Aye. All opposed? None opposed. A motion to table House Resolution 23-3 has been adopted. Next item. House Bill 23-8 to require all contractors to be licensed in the Commonwealth of the Northern Mariana Islands. Floor is open.
Madam Chair, short recess.
Recess. Recess. The last we left was 23-8, and that would be pending in committee. Moving along, 23-9, to require legislative appropriation for all non-locally sourced funds allocated for the Commonwealth of the Northern Mariana Islands. The floor is open.
Madam Chair, if I may,
Sure.
may I ask that we also leave House Bill 23-9 for further review in the committee and that we leave it pending in the agenda?
Second. Okay.
Okay, no,
All those in favor, everybody agrees, and 23-9 will be pending. Moving right along, 23, House Bill 23-13, to amend the Crimes and Criminal Procedure Code definitions of dangerous weapon and serious bodily injury. Floor is open. And at this moment, I'd like to allow the members to ask questions to our panel, most especially the AG's representative, Attorney Glass. If you have any questions regarding this, please address it to him. Thank you. Congressman Sablan.
Thank you, Madam Chair. And maybe perhaps I can a question to Mr. Glass. I understand that there are some concerns from the public defenders on this piece of legislation. Are you happy enough to like kind of explain what are those concerns? Are you aware of that?
I'm not with the public defender's office, so I'm not sure what their issues might be with the bill. I will say from our perspective, as the AG's office, we're in support of the bill. I believe we've already provided our written comments as well on this, and so I can't specifically answer what their issues might be.
Thank you. Fair enough. I yield, Madam Chair.
The floor is still open. I have a question. Just recently, there was a case in the federal court regarding a police officer providing a cell phone to one of the inmates. Is that correct? Corrections officer, right? Providing a cell phone to an inmate. And I believe this particular legislation will fix that, right? We can address, I know a cell phone is not anything to do with what is defined as contraband, right? Or drugs or what have you. But would this kind of fix that problem on the local side?
Yeah, thank you, Madam Chairwoman. So I think the contraband bill, which is House Bill 2317, is where that would come in for the cell phones. This particular bill dealing with a dangerous weapon really deals with items both out in the public, right, and in the prison. And so, for instance, I know like in the past we've had cases where like a frying pan was used to hit someone over the head multiple times. And that can be a dangerous weapon, right? If you're using it in a manner that can cause serious bodily injury or perhaps death, right? The manner of use. Now, frying pan, obviously, in and of itself is not a dangerous weapon, but things like guns and those are dangerous weapons. But when you get to a prison setting, specifically dealing with dangerous weapons, many items within a prison can be turned into what they call shivs, right? Where they sharpen things. The particular case that we kind of referenced was where somebody used a toothbrush and they took the handle end of the toothbrush and they sharpened it into a point so they could stab someone with it, right? So that's not quite cell phones and those things. I don't have all the details on the federal case. Obviously, I'm not a federal prosecutor, and that is an ongoing case. So even if they were here, they probably couldn't comment on that. But I believe that'd be the contraband bill that would specifically address things like cell phones, other items that may be brought in, like nail clippers, those kinds of things that might be brought into a prison. This one is going to deal with items in a prison and outside the prison.
The floor is still open.
Madam Chair, I move that we adopt House Bill 23-13, and we have our legislative assistant prepare a committee report for its passage in its current form. So move.
There's been a second to support the motion. All those in favor say aye. Aye. All those opposed say nay. Motion carries to support and pass this House Bill 23-13 to amend criminal and crimes and criminal procedure code definitions of dangerous weapons and serious bodily injury. Okay, moving right along, 23-14 to amend the punishment for crime of vandalism to include the option of confinement. Floor is open for public comments. Again, directed at Attorney Glass. Should any of the members have any comments? Thank you.
Madam Chair.
Rep. Sablan, go ahead.
Thank you, Madam Chair. And as previously discussed on our informal meeting of the JJO committee, maybe perhaps looking into using provisions as like up to, so that the judges can weigh the penalty on each violations. And maybe perhaps we have some lawyers from the court. What are your thoughts on the provisions, instead of setting a cap for the judges, giving that flexibility for judges? You guys are in liberty to discuss. Thank you.
Any comments from the panel?
If I may, Madam Chairwoman.
Sure.
I believe the current language says for not more than, which would be almost identical to up to. Both of them are limiting principles, which would limit for each of those, the max would be 10 years, 5 years, 1 year. And so the judge would already have the ability to start at 0 and work up to those 10, 5, and 1, depending on the severity of the category.
Thank you for that clarification. I yield, Madam Chair.
Thank you, Congressman Sablan. Floor is still open. Congressman Camacho?
Is that, oh, sorry. How is that gonna work? Adults and young people do vandalize, but I didn't see anything here that actually qualifies age group wise, misdemeanor or felony. Can you clarify? Thank you.
Certainly. Thank you for that. It's a great question. Currently, we have a juvenile justice system. So anyone that is younger than 18 is placed in before the juvenile court. People that are over 18 are placed in adult court. Now, there are certain provisions that allow juveniles to be placed into adult court, but that's usually not in the vandalism context. And so there's already provisions within the law that would protect minors from being placed into adult categories and settings. And that would encompass, and it already takes care of any kind of they don't really call it jail time in the juvenile justice system, but the same kinds of principles there. And so right now, that's not a concern specifically for this bill because there's other laws in place that will already protect and separate out those two categories of individuals.
Thank you for that. Thank you, Chair.
Any other questions? Floor is still open. Recognize Vice Chair.
Thank you, Madam Chair. And as previously discussed in our informal JGO meeting, I move that we have our legal counsel, Mr. Bradley, work on the substitute changes.
We've already finished the substitute, and she has a copy. We can move to adopt.
Okay. I move that we adopt the substitute version of House Bill 23-14 in the form of House Substitute 1. So move.
There's been a motion to adopt House Bill 23-14 HS1 substitute. There's been a second. All those in favor say aye. Aye. All opposed? None. Motion carries to adopt House Bill 2314 HS1.
Madam Chair, if I may.
Vice Chair, go ahead. You're recognized.
I now ask that we return to the main motion and adopt House Bill 23-14, House Substitute 1. So move.
There's been a second to go ahead and move the House bill. No objections from the committee. All those in favor say aye. Aye. All opposed? None opposed. Motion carries.
Madam Chair, I would also like to recommend that our legislative assistant prepare the necessary committee report. Thank you.
Noted. Okay, moving right along. House Bill 23-15 15, to amend Title VI of the Commonwealth Code by adding a new chapter to enact provisions associated with public corruption, other unlawful influence, and related offenses for public officials and for other purposes. The floor is open for comments. Attorney Glass, it looks like you want to make a comment.
No, Madam Chairman, I'm fine. If there's no questions. Again, our office is willing to work with the committee on this. I don't think we've provided any comments from, for this specific bill at this time. So,
No other questions? Vice Chair, you're recognized.
Thank you, Madam Chair. And with the comments received from Attorney Glass, I move that we keep House Bill 23-15 pending in our agenda. So move.
There's been a motion, it's been seconded. All those in favor say aye. All opposed? None opposed, motion carries to leave House Bill 2315 pending for further discussion and comments. Item H, HB 2317, to provide clarity relative to the crime of promoting prison contraband, or otherwise known as the Contraband Reform Act of 2023, and for other purposes. The floor is open. Recognize Representative Sablan.
Thank you, Madam Clerk, Madam Chairwoman. And at this time, I want to thank the Office of the Attorney General for their support on House Bill 23-17. At this time, I want to offer a House substitute. So move on House Bill 23-17. I believe the Attorney General's office and our legal counsel had worked on this substitute so offered.
Second on that motion.
There's been a seconded, and there has been a motion to adopt the Contraband, or House Bill 2317, the Contraband Reform Act of 2023, substitute submission HS1. All those in favor say aye. All opposed? Motion carries. Oops, I'm sorry. Representative Sablan, were you done? Yes.
Thank you, Madam Chair. And at this time, I make a motion that we adopt House Bill 23-17, House Substitute 1, and have our LA staff formulate a committee report. So move.
There's been a motion on the table to adopt House Bill 23-17 in substitute form. Provided the clerk will submit that. There has been a seconded. All those in favor say aye. All opposed? Motion carries to adopt House Bill 23-17 HS1. Thank you, Rep. Sablan. Item number 4, I'm sorry, members, when I had printed this agenda, the deadline, there was a deadline there that states March 25th, 2023. And for the life of me, I cannot figure out what that meant. So I apologize. I'd like to, go ahead and skip that and move along to item, sorry. Thank you, John, for that clarification. And apparently it had to deal with the judicial rules, and we had one withdrawn. So that's why that date was very, it stuck out to me, because I wanted to have that deadline for our committee to get together with the judicial court and get the comments. But since one was withdrawn and you guys made comments on the guardianship, that's really what that was. Thank you, John, for that clarification. I appreciate that. Moving along to item 5, can I get a motion to adjourn? It's been seconded. There's been a motion to adjourn. All those in favor say aye. All opposed? We are now adjourned. Motion carries. Thank you very much, everybody.